Greetings, dear friends. Several technical announcements. We've got simultaneous interpretation today. If you need that, the headphones are over there at the back of the room. Please take the headsets and then put it back, please. We are going to have two languages today, Ukrainian and English. In Zoom, we also have the function of interpretation. Please find the globe icon.
We will have a simultaneous interpretation, so please use the headphones if you are in person. They are right in the back of the hall, and if you are joining us online, you will have the switch language option in the Zoom, so feel free to use that. Для гарнітури
Speaking about your headphones, A channel would be Ukrainian, B channel is for English.
B is English. І, в принципі, це
And in general, this would be it. If you have any questions, we'll deal with those. And I give the floor to the head of the ULAG, and you will proceed with everything, right? Okay, I'm not going to take my seat in the presidium then. Good morning. Thank you for coming. I believe I shall start. Well, the presentation of the report is the good pretext, and we've presented it for several times already. The first iteration of the report was presented in The Hague in summer 2024. Then in September, the Ukrainian variant was presented, and we had a very fruitful discussion. And now we are presenting the update. We've prepared it with the support of International Renaissance Foundation, IRF. Thank you so much for this support and for believing in us, because this is really something well needed as of today. But in general, this is a good pretext to discuss problems, challenges, ways to bridge them in the context of the criminal law and bringing to liability those who committed the most severe crimes. And also this is the good opportunity to discuss the context which we currently have around this topic, because we know that the peace talks are taking place as we speak, and that's the good opportunity to discuss expectations and the extent to which we can influence and whether we need to influence this very context. Well, for sure, for the whole world, the priority issues would be to put an end to the war which was launched by the Russian Federation against Ukraine in 2014, meaning that's 11 years ago, and they proceeded with the full-scale invasion in 2022. And there are discussions, negotiations as regards the conditions of peace, what rare earths shall be provided to whom, and what security guarantees will be granted. We are still worried about the issue of justice. The justice issue is somehow not there at the surface, at least based on our monitoring. We don't see that the issue of justice is high in the agenda, but it's obvious that bringing the perpetrators to the liability would be the key guarantee of non-recurrence, and that's the guarantee of security. We hear from various unofficial sources that there won't be any liability. There's a court requirement from several parties, including the Russian Federation, to stop all the prosecution. And if that's the case, and if we look back at the history and the lessons of history, those who committed severe war crimes are not punished, there won't be any just and durable peace. And we don't want to be country number 105 that's repeating the mistakes of the history, because the decision makers did not learn the history properly. And the key thing would be that that's the luxury we cannot allow ourselves to have. We understand that the suffering would be in vain. And that's terrible for those parents who lost their children and for the children who lost their parents. And those who lived through all these horrible things of war shall have the moral forces to rebuild their country and to believe in their country, because namely people would be doing this. They shall have hope, and there shall be serious transformational processes which would yield in bringing to liability those who caused this suffering. And people need to have an opportunity to be heard by the state, by the perpetrators, by the society, and there shall be the truth-seeking. Everybody shall understand what they went through, what kind of physical pain and moral pain they had, that they lost those whom they loved, and a lot of people lost their lives because, our major task would be to survive here and now. But this task will be relevant after the war is over, but not just to the physical threats, but due to the soul pain we are going to face even after the war is ended. So the transformation of this pain is the task of the high quality justice in this regard. So the architecture, the system of justice shall be constructed in such a way in order to face all the challenges and bring justice to everybody, experts, diplomats, civil society, etc. We need to help people restore their trust and be hopeful that we still have a lot in our lives to fight for, and that the war and the pain is not the end of the life as we know it. So please share your opinions, your feelings, be constructive. We don't have that much time, and actually we are really paying too much for ignorance of all these issues. So let's hope that we will achieve the durable peace. Mr. Roman. Thank you so much, Nadia. Nadia mentioned a lot of important things, and I would like to mention that we, as the Renaissance Fund, IRF, since 2014, are trying to do our best in order to have all the information needed to pass all the necessary decisions to develop the judicial system of Ukraine and to pay attention to the needs of the victims and survivors. And I can't tell you that as of now we have huge successes in this, because quite often the decision-making is dictated by certain other factors, and we need to properly understand what's taking place on the ground and in what way the bird's view picture looks like. Somehow that's not always our approach to understand this bird's view picture. So, as an IRF, we were looking into the war crimes committed since 2014, before the beginning of the full-scale invasion. There were so many discussions around this topic. It's difficult to actually even know the number of these discussions, but somehow the decisions that were made didn't really take into account the results of these discussions. And even the fact that so much time passed since 2014, since the moment the armed conflict was brought to the territory of Ukraine by the perpetrator, legislation is still very far from being an efficient tool of any procedural actions, and the system of organizing investigations of war crimes is still very far from being efficient, effective, and optimal. And there are no huge discussions around these topics, and it's very difficult to find the stakeholders whom we can resort to with all these problems and challenges. And if we have a look at where we are now, the situation changed significantly. One of the things that make us confident, within these recent 3 years was actually interaction with our international partners, with the international mechanisms. We have a significant amount of projects that are helping, and great experts and expertise which are quite unique, and we've involved the best experts from the whole world. The European Justice Mechanism, Universal Jurisdiction Mechanism. We also have some cases in International Criminal Court and even the arrest warrants within the ICC rulings. And now we find ourselves in a very complicated situation. If we have a look, again, from the bird's view, the prospect of the investigations by ICC after United States sanctioned them, they just started sanctioning them. We don't clearly know what would be the future of this process. Within the framework of universal jurisdiction, so far we don't clearly see some efficiency achieved, especially taken into account that there are other mechanisms like investigations carried out in Ukraine, as well as investigations conducted by ICC. Thank you, beg your pardon. And it poses a question: how come other countries within the framework of their national jurisdiction shall investigate crimes that were committed within the territory of Ukraine? And there's no systemic answer to that. And we don't see a lot of enthusiasm in the eyes of our partners in this regard as well. And as Nadia has correctly mentioned, if we expect this process of looking for reconciliation and establishing further durable peace can result in turning a blind eye to the war crimes committed by the perpetrators. And unfortunately, this can be well expected. We've heard about this within the framework of so-called Minsk process. And, I would be surprised if these issues wouldn't be raised during the decision-making. And taking into account that one of our strategic partners, as we see, selected the tactics of not calling aggression the aggression and be silent about the war crimes. This means that this approach can be well expected, unfortunately, that we will turn the blind eye towards the war crimes. That's the situation we find ourselves in now. And the scale of the conflict is huge. Europe didn't see it since the times of the Second World War. I'm not here to compare the scale of the suffering, for example, during Balkan Wars, but we can speak about huge destructions, very significant amounts of survivors and victims, and that's difficult to achieve reconciliation with this. Impunity cannot win. We don't want to find peace with this. I believe that's very important that we have a lot of empirical materials and that we get more and more data in order to have an opportunity to discuss the relevant state of affairs as regards liability for war crimes. Today we have a huge opportunity, a great opportunity to discuss what options are out there and what can bring us all together, what can we do together, and where we have not yet achieved consensus and we need to proceed with consultations. I believe both approaches are of paramount importance, and I would really like this discussion to be pertaining not to those points where we are united, but it should be pertinent to actually those issues where we don't have some common grounds. And all these versatile opinions are going to be discussed in the course of negotiations, and we need to proceed finding some common grounds around all these processes.
Well, this is what I'd like to say in the beginning. I would ask you to be as frank and sincere as possible in those conversations, because what really unites us is the common interest, so that justice could really take place and impunity wouldn't win. Thank you. Thank you, Roman. Let us move on to the discussion. I would ask my panelists to join us on the stage. My name is Alina Pavluk. I'm the coordinator of the lawyers' work and the analyst of the Ukrainian Legal Advisory Group. So we will begin our first panel. It would be much more convenient to climb it from that side. So we'll begin our discussion on the debate what took place recently at the national level. I do apologize, I need to step in front of you. So, as Nadia has already mentioned in the beginning, this research which you have seen at the registration stand, the assessment of capabilities of the national justice system, is a living organism for us, which is, well, at least we are trying to update it in the process. We try to follow the tendencies and amendments to the legislations which are taking place during the recent times, and looking at the fact that even during the 1.5 years since the main text has been presented, we had lots of changes. We also added separate issues about, for instance, the legal guarantees for the protection of the justice workers, justice systems, employees, the necessity and the state of the legislation on the procedure of the evidence transfer which we have in the criminal procedure, the issue of harmonization, and it was also highlighted in the research. I would like to introduce my panelists as of today. Ihor Kalantai, head of the Department for Organization of Investigation of Crimes Committed in the Context of Armed Conflict, Main Investigation Department of the National Police of Ukraine. Andriy Leshchenko, deputy head of the Department for Procedural Guidance and Prosecution Support of the Department for Combating Crimes Committed in the Context of Armed Conflict, Office of the Prosecutor General. Marina Bondarenko, judge speaker of the Darnitsa District Court of Kyiv, and Volodymyr Yavorsky, program director of the Center for Civil Liberties. So before we begin this discussion, I would like to mention in a nutshell what we used to observe during the last half of the year. And of course, one of the main pieces of news which framed the following development, at least of the national level, is that Ukraine has finally ratified the Rome Statute of the ICC. And since the 1st of January 2025, it has become the fully fledged member country. It has been a long way, which was at least accompanied by a huge number of myths and still a huge amount of support of the civil society and justice authorities about the necessity of its ratification. And its finalization, in fact, has become the adoption of the political decision that finally we should join the system. Still, we got certain warnings on the Article 124, and one of the assignments for us now is to define what will happen next, how we'll act within this decision. So, after the ratification process, there have been amendments introduced into the criminal code of Ukraine. Finally, we have the crimes against humanity. We've got the universal jurisdiction at the national level, the definition of command responsibility, but still a huge number of issues is still unsolved. That is Article 438, war crimes. However, they changed the name, but the wording is the same. And the same is about the crime of aggression, which has not changed in its essence. Still, in spite of the huge number of discussions, we do not see any issues raised at the level of the necessity of amendments to the CPC of Ukraine, the Criminal Procedural Code, because still the standards of the investigations and approaches to the investigations of the crimes are still far from what is required by the most severe international crimes. And also lots of discussions have taken place because of the specialization of the judges at the national level. And rather unexpected news was that in the first reading there have been a law draft voted for on the specialization of judges on the investigations of the war and military crimes, and still the open issue is whether such approach is efficient and practical when we have a critical lack of judges and a huge workload which is still there during a long period of time already. That is why, gradually, let me move to our discussion. As my dear speakers were warned, I'll have separate questions to each of them. Igor, I will begin with you. So far, we are in the situation when the investigators of the national police are the ones who are the first responders coming to the places to investigate the crimes, to the those who have the biggest number of war crimes in the investigations, and still they don't have the predefined jurisdiction. Unfortunately, according to the Criminal Procedural Code of Ukraine, it is like that. So I'd like to hear your opinion. What do you think? Which amendments to the Criminal Procedural Code, first of all, are needed now so that we could help to efficiently investigate and help your work in practice? Thank you. Do you hear me? Yes. So, good day. Dear presentees, Alina, thank you for the invitation. National Police, the main investigation department, participation is so important in this event. Thank you for appointing me as the first speaker from the law enforcement system about the issues raised in this event. I do apologize for my tone of voice. I'm a bit sick, so I do apologize for that. So, if I may, Alina, let me delve deeper into history about the participation of the national police in the system and work on the documentation, registration and investigation of the war crimes, considering the above-mentioned block in the report about the national police. I need to introduce some of the amendments because I understand that the report itself was prepared before. So during this time there were lots of changes in the national police as well, which can be included into the following reports, I guess. First of all, I'd like to mention that the national police, since the first days, has started the active measures on the documentation and responding to the crimes connected with the war. Since the first days of the full-scale invasion, but also when the Russian aggression started since 2014. At the moment, the national police has created certain structural units in 3 regions which were the most affected because of Russian invasion: the Crimea, Donetsk and Luhansk regions. Obviously, the most active was the main department of the Crimean Peninsula of the national police, of course, which were the first to started the process of the work on documenting of crimes in the context of the laws and customs of war violation, that is Article 438, which was not that frequently used then. That was a novelty for us, an innovation. But I think that thanks to these first steps, we already had experience which helped us during the first days of the full-scale invasion and to quickly move to the investigation of war crimes specifically. So, as for the first and foremost measures conducted by the national police during the first days of the full-scale invasion since February 2022. First of all, documenting war crimes, responding to all of the notifications about this or that committed crime was done by the police officers. We understand why it is taking place, because in the law enforcement system of Ukraine, police is the first authority where the citizens go to. The police officers are working under different conditions depending on the region where such actions took place. Even if it was during the occupation, the police had to comply with its obligations, even being located or being on the territory which was under occupation. So the biggest number of registered crimes connected with the armed aggression of Russian Federation are in police. I'm not only speaking about the classical article of 438, but other articles as well, which to this or that extent we consider the crimes connected with the armed conflict. Those was also the article which was recently implemented, the new article of collaborationism, which never existed before in our legislation, and the understanding how we should qualify the actions of the Ukrainian citizens who decided to be on the side of the enemy since 2014 on the territory of Crimea, Donetsk and Luhansk region. We couldn't have such an opportunity before, so we had to find other articles like the participation in the illegal armed formations or other articles. Sometimes we even used Article 250, that is the terrorist act or the organization of terrorist activity. But those articles did not comply with the sense which we needed to include into the crimes of the citizens, Ukrainian citizens who moved to the adversary side. Well, sorry for this deviation from the topic. Today, since the beginning of the full-scale invasion, we registered more than 126,000 crimes which are qualified by the Article 438 by the National Police. So that we could efficiently conduct investigation of such crimes, the National Police has created specialized units in its structure. The first was the Department for the Organization of Investigation of Crimes Committed in the Context of Armed Conflict. I am its representative. I am the head of the second department, which deals with the organizational, analytical, organizational, methodological, and control function over the investigation units, which deal with the war topic. To be short, to be brief, in the units all over the territory of Ukraine. The next step was the creation of the specialized units in the regions which were the most affected by the Russian aggression. As of today, and it's already the correction to your report, we have 12 units like this all over Ukraine. Those are all of the regions which to this or that extent were affected by the Russian aggression, which were occupied or partially occupied or occupied but then fully liberated. I will not list them, those 9 main regions. And also the regions which to this or that extent are most affected by Russian aggression. That is Dnipropetrovsk, Odessa region, Kyiv city as the key region where the Russian armed shelling is taking place most of all. So it gave us the opportunity to structure our work, to create the full review and control from the central authority of the National Police and main investigation department to the investigative units which are dealing especially with the war crimes. In this way, we were able to accumulate the activity. The investigator who will or is already investigating such crimes will be provided with the necessary analytical materials, will organize the necessary trainings in the sphere of their work, and will also provide all of the necessary technical means which can help us in that. So, well, soon I will move to the question which you posed. I just wanted to introduce the context. So this is how the National Police investigates such crimes. And if it's possible, a short remark about the figures which I mentioned above. The outcome of the investigation of our of these crimes investigated by our police, it's not that substantial, but it's more than 500 notices of suspicion by Article 438 by the investigators of National Police. The majority is in absentia, obviously, but we have certain really specific, real persons with whom we had to work in Kyiv region. We don't only convict in absentia, but we also work directly with the war criminals. As of our further actions, understanding the situation, with the fact that national police is an authority which has the most resources and opportunities and experience on the investigation of any types of crimes, in this case war crimes, during the 3 years of our gained experience, the management of national police as the main investigation department took a decision that we need to somehow structure our further steps and accumulate them. Sorry to interfere, but you have only 2 minutes left. Okay, let me shorten my speech. In January this year, the National Police has presented a strategy for the investigation of crimes committed in the context of armed conflict or international crimes. This strategy foresaw several objectives. One of the objectives is to help organize and harmonize the national legislation in the context of the highest possible convenience for the work of investigators, in particular for the investigation of international crimes. We thank the Parliament that they adopted the law on the harmonization of legislation and ratification of the Rome Statute according to that, but still this law did not foresee all of the opportunities which could have helped to work more actively for the investigators of the national police investigating war international crimes. That's how you mentioned, Alina. This is the problem with jurisdiction, which is still open and is still not solved. Why is it an issue? Because we are losing time. We are wasting time. The process of transferring of the proceedings from the security service to national police takes some time. We lose some evidence. We lose some opportunity to document with the high quality and quickly document the facts of real committed crimes. Secondly, what we can see as a problem, and which is still not raised, is the issue of retrospective nature. Now we've implemented one type of war crimes which was never used before in our legislation. Those are the crimes against humanity, taking into account the circumstances that we have already developed a huge number of facts of war crimes which can be considered in the context of crimes against humanity. We still do not understand whether it will be possible to use them further on to qualify the actions of the war criminals by this article. We understand that the implementation of the article number 31 prime 1 into the criminal procedural code on the common responsibility is really timely. Well, no, it's not timely. We wish it was adopted before, but still, considering that we don't have developed practices of the use of this norm, we would also like to understand how we'll implement this article and enforce it, because it has certain issues within it, on the wordings and not only, and on the use of it as well. That's in a nutshell. I don't know whether I took 2 minutes, maybe more. I think that further on I can go on with this topic in the discussion. Thank you, Igor. I will come back with the questions to you. Now I give the floor to Andriy as a follow-up to what Igor started to speak about. Out of what we already observe with the amendments to the criminal code on the issues of harmonization, so far, in spite of the activation of the process, we understand that again it can be suspended and paused. We don't know how the process of harmonization will go on. Still, my question is the following. Which of these changes and amendments can be still offered to the criminal code and CPC? Which of them are still relevant? And how can we make them how can we lead to the fewer issues? Because we have lots of issues with that. Requalification, the issues to qualification. How can we simplify and make these further solutions applied? Thank you.
Hello, everyone. Andrei Leshchenko, General Prosecutor's Office. As regards the issues and the questions you've just asked, investigative judges, prosecutors, they are not legislators. They are just using the legislation which is out there, and they are working with the tools that the state had given into their hands. And every time when the tool set is changing, it causes certain processes which need to be tested, and it urges us to think out of the box. Now we've faced the challenge that there were certain amendments introduced to the norms of the criminal code, and we have further discussions as regards introducing changes to Article 438. And so far, this article is quite universal, and it actually refers us to the norms of the international humanitarian law and any crimes that can be covered by this very article. They are stipulated there in the international treaties. Now, if we model the situation when we introduce into our criminal code the exhaustive list of the four forms of behaviors of the war criminals, and the criminal code would be saying that this and this actions are war crimes, we can face the situation when certain forms of criminal behavior of certain people won't be covered by these amendments, won't be mentioned in this exhaustive list. And in that case, we would have a situation where before the amendments were introduced, we could actually bring that person to liability according to Article 438, but after the amendments are made, we would not be able to do so. We still need to discuss it in all the details, investigate it all in order to assess all the necessary risks to make certain conclusions. But whether we need in the future to move into this direction, still a question mark. Maybe yes, maybe no. And the key task of ours here, as the civil society, as the authorities that are relying on Ukrainian legislation, would be to understand the nature of the crime, understand possible consequences, and understand the tools, in what way to counter these crimes and to bring the perpetrators to liability for these very actions. That's the key challenge as I see this. If we speak about Article 438 and actually the aggressive war, implementation of the Roman Statute in this regard did not open up any additional opportunities for us, because the jurisdiction of ICC is not covering the crime of aggression within the situation happening in Ukraine since 2014. So we shall be relying on ourselves and say that we, as an independent country, as the law enforcement system, will be doing our best to collect the evidence, and will be bringing perpetrators to liability based on this article, or that we export our judiciary externally, creating some other judiciary body which will be bringing to liability for the aggression crime. And with due account of the fact that the nature of aggression crime would be using force by one country against the other country, the most optimum approach here would be creating this other alternative body beyond Ukraine. And such processes are taking place, and they are actively discussed at the level of the EU and in general the whole world. Periodically, we see meetings of the representatives of foreign affairs ministries of various countries to discuss this issue. And I believe there was this range of statements and publications that this year, even in the first half of this year, countries of the EU or countries which are part of this core group are willing to sign the statute of this tribunal, which would be the first step to creating this international judiciary body, which would have jurisdiction over the crimes of aggression, bringing to liability those who are to blame of these crimes. This mechanism will allow Ukraine, as the country that suffered unjustified aggression of the Russian Federation, to show the whole world our will, and actually it will enable us taking tentative steps. So we also have an opportunity to do something similar at the national level, meaning bringing to liability those leaders who are responsible for the crimes of aggression. But we understand In what way these rulings will be enforced? Unfortunately, there are no great mechanisms of enforcement because we all understand that those persons who committed these crimes are not within the territory of Ukraine now, and maybe they won't come back to Ukraine, meaning they won't find themselves within the jurisdiction of our national courts, which is why actually enforcing the ruling of the International Court would have better consequences for the perpetrators, but this is still the question for the future. So far, we are working on preservation of evidence of the crime of aggression, collecting that body of evidence, and we are very grateful to the international community for that, especially Eurojust, and they really provided us an opportunity and provided the funding to collect this evidence base, to safely store the pieces of evidence, and to create such a portfolio of prosecutors' materials that could be given further to the prosecutor's office of the tribunal for those representatives of the tribunal to make a decision what pieces of evidence are needed, what additional pieces of evidence shall still be collected. Maybe we can really prepare something solid for the first indictment acts. So the issue of introducing changes or amendments to the legislation is really relevant, but we need to do that really wisely and cautiously because such processes might have both positive and negative consequences. And my personal point of view here would be that we need to harmonize not just Article 437, 438, but also those articles pertaining to war crimes committed by Ukrainian service persons, because actually there's a range of articles on looting, inappropriate treatment, integrating treatment towards the civilians. But again, the level of liability does not reach the level of liability stipulated by 438, which is in contradiction with the Geneva Convention, which stipulates equal liability for both sides of the armed conflict. And well, as I say, this is a very urgent issue. Again, if we speak about command responsibility of the commanders who had given this orders, there's Article 436.1.2 that contains the norms, which are the norms which allow bringing the representative of the armed forces of Ukraine to command responsibility rather than representatives of Russian army only. This is not a new article for us. We had several criminal cases that were investigated under this article with the use of this principle I've just mentioned. But again, it must be brought into compliance with the appropriate articles which pertain to command responsibility of the representatives of the Russian armed forces, because, it might be the case when the representatives of Ukrainian army would have less years behind the bars compared to those from the Russian army, and this could negatively influence the reputation of our country at the international arena. Thank you so much, Andrei. I just wanted to stop you there. Very logical. Thank you. Now the issues of amendments to the legislation. And Ms. Marina, this question would go to you. In the context of specialization of the judges, we were discussing this already with you before. And what's the trend? What's the tendency now with this possible amendments to the legislation? So far, we don't know whether these amendments are going to be passed. So what's the potential practical meaning of these amendments if we speak about specialization of the judges in terms of certain judges considering the war crimes, or are there any alternative approaches here? Greetings, everybody who's present at the event. Well, to start with, I would like to briefly mention a few words about the report we are discussing today. I'm very grateful for inviting me. I'm very happy to discuss the report. This very report is quite different from the first version of this document. And what I noticed within the report too, the number of challenges and the number of problems are accumulating. I strongly hope that there will be the reverse process very soon. Speaking about specialization, well, this is going to be something efficient and effective. There are three components and three elements within this I would like to highlight to prove that it's going to be something efficient. First of all, that's about quality. Second of all, that's about the balance of all this architecture of justice. And thirdly, that's about resources. What do I mean when I say achieving the healthy balance in the justice architecture? We know that so far they've introduced specialization into the pre-trial institutions. The prosecutor's office, Mr. Ihor mentioned that. I looked at the most recent report of the general prosecutor's office. There's the map of Ukraine where they mentioned where there is specialization in what prosecutors' bodies, maybe 11 regions of Ukraine are mentioned there. This is something that have already happened. The specialization was already introduced there. Also, there's going to be the subnational or national level. The hybrid tribunals are going to be created, bringing the countries together, meaning combining the national and international participants, actors, and it seems that in this aspect, at least at the national dimension, we are somehow losing the Ukrainian courts within this all, and specialization would not mean that much. So, in what way the specialization is going to be introduced, that's difficult to say. The draft law passed the first reading. Now this issue is being discussed, and it would be logical if specialization which would pertain not all the district courts within the whole Ukraine and not all the appeal courts. Why I mentioned implementation of the specialization, that would be logical to have specialization in those regions where they have the pretrial investigation bodies and the prosecutor working together. Well, by the way, in your report, you mentioned specialization with the anti-corruption purposes, specialization at the level of constitutional court. But at the very same time, you don't mention the specialization within the juvenile system we currently have in Ukraine. I believe this would be really great to have the same approach. Juvenile specialization of the judges would mean splitting the cases by the priority, and only then all the other criminal cases shall be considered. We can actually implement something like this in the courts which deal with moderate numbers of war crimes. In the report, you mentioned Irpin court, and it makes no sense to introduce specialization there. Speaking about quality, yet another pillar. Specialization is always about quality. Am I not right? It's actually the case in other areas, not just in the judiciary system. Well, at first, it seems that the draft law mentions specialization on war crimes. Well, at first, we understand that the specialization is due to various factors, but still that's a good managerial decision, and it shall be the case if this draft law becomes a law. That would be logical. And you understand, as the judge considers the war crime, as the judge, you can actually understand what's the essence of the crime there, what are the elements there, and usually there would be more than 4 elements, material, procedural, etc. You can pretty much dive into the practices of tribunals, but at the very same time, you already have to have a profound understanding of international humanitarian law, all the principles out there of immunities, of privileges, of protection as regards civilians. So everything you have got on hand could be assessed properly in order to avoid the judicial error. So We understand this is the priority crime. We live under the conditions of war 11 years in a row, but these rulings would not stay at the national level, and we don't speak about just one judge at one court. And this is not the issue in what way international partners are going to be familiarizing themselves with these rulings. These rulings of the court could also become the future evidence. So the issue of quality is again of paramount importance within this judiciary processes. And thirdly, the issue of resources. We have to speak about this as well with due account of geopolitics, which we are facing as of today. So actually, the specialization of the judges would be about really targeted action, about targeted valuable assistance, international assistance granted to Ukraine. And this will mean preserving resources and time on both sides. That's my answer. Thank you so much, Ms. Maragna. And actually crowning up our reflections on the amendments to the legislation, let me go back to Volodymyr. Based on what we see as response of for example, law enforcement agencies to these changes, for example, crimes against humanity automatically results in let's register this cases approach, and a lot of discussions, a lot of decisions were there offered as regards certain internal strategies. And one of the examples provided by Mr. Ihor was that now at the level of the National Police of Ukraine, they're trying to implement certain approaches. So in the context of these priorities and the vision of the judiciary in general, can we somehow understand what are the priorities of the system with due account of the existing strategies and whether they are practically applicable? And in what way potentially it can result in further amendments to the legislation? This one doesn't work. I'll borrow yours. Hello. In the first place, I'm very grateful for the second version of this report. I strongly hope that within years it won't grow into multiple volumes because, it increased significantly and we see more and more challenges mentioned in the report. I would really like this document to become thinner with time. So, I always open Article 138. Oh, no, it's 130. And I see this phrase. Oh, it's okay. Within the whole history of the prosecutorial bodies in the history of Ukraine, the key factor is still the political will. Then I can just, close this book and finish with the discussion of the priorities. We don't have a public conversation as regards prioritization. This dialogue was there with a certain group of international experts at the prosecutor's office, but there was never a frank talk with the civil society conducted openly. I don't know how to comment on that, though that's actually the part of the investigations of the prosecutor's office. They passed within days, and actually I can't find answers to plenty of problems in that document, and I see these problems are raised in this document. For example, torture crime. I believe this is one of the most brutal crimes which can be out there during the war. It shall be obviously the priority within the investigations, and I believe it's not the priority somehow. Why am I sure of this? Because I see Ukrainian POWs coming from the territory of the Russian Federation. I see in what way and at what level the investigative actions are conducted. I know that the Kharkiv human rights defenders have got 600 clients with the cases of torture, and somehow these cases of torture are not being the priority for the prosecutor's office. And there's going to be this snowball effect in few years. Ukraine has got international liabilities to actually procedurally investigate using Article 2 and 3 of the European Convention, and actually this these cases sooner or later will find themselves there at the international court if Ukraine fails to investigate it all properly. And in general, as we see, everything is based on political will. I look at the shootings during the Revolution of Dignity at Maidan. Somehow the political will was not there to investigate it. And very often we operate with statistics, but that's a harmful approach because at certain point in time, the statistics becomes the goal. For example, police is saying, well, we've got 126,000 of criminal cases according to Article 438. But what's the specifics here? Over 60,000 of these cases would be about missing persons, and these cases shall not be the priority for the investigative bodies because the key goal of these cases would be to find the person and only then have a look whether there is the body of the crime in this very situation, etc.
So why is it like that? Because in the Ukrainian legal system there cannot be a missing person if the criminal case is not registered. And even there can't be a DNA expertise if the criminal case is not registered to search for a missing person. So in fact this mechanism is blocking lots of investigations because hundreds of investigators of the national police are overwhelmed with 2,000 or 3,000 of cases of missing persons, and there is a huge paperwork on that. So these are the indicators which are spoiling the understanding of what we are doing. In fact, there are several important components of the systemic policy on the crimes investigation. The proper legislation, the working group in the Prosecutor General's office as of today is just warming up. It's not even slowing down because it's not meeting. And I don't see any perspective when it is going to work in the active way. Now we are speaking about the amendments to the legislation, and jurisdiction is the consequence of that, because in fact, if we do not have the specifically defined body of crime, then the issue will be the jurisdiction. Secondly, the system of investigation bodies, because again, as of today, it is not predefined. We have some of the groups of investigators, and there are some problems with the jurisdiction in the national police, but there is a key issues. What is expecting for us if we'd like to get to the EU? There should be the reform of the security service of Ukraine, which shouldn't have any investigation functions. It is not their inherent function in the special intelligence service. And we don't have this understanding because it is going on the opposite. We have even more and more concentration of investigations in the security service of Ukraine. So far, I think that it should be done in the national police, and we need to have a unified authority for the investigation of such types of crimes, I mean international crimes, because without that we cannot get the sustainable and progressive progress in the investigation of such crimes. And separately, we need the system of search of people who are to blame and their assets abroad. It is not enough to say that the Interpol is blocking these investigations. We are working with Europol. We can have bilateral deals with certain countries and treaties. There are numerous mechanisms which can be used. We can use the Convention on forced disappearances, which Ukraine has not implemented so far, but it is specifically foreseen that Interpol cannot block international search by these articles because those investigations cannot be defined as political ones. Ukraine has never used the provisions of this convention as of today. So I think that not enough, really not enough is done in this sphere. We should have done much more in that. Altogether, there is a broader context of investigations because now, for instance, in March, there will be the meeting of the Committee of Ministers of Council of Europe, which will define the list of measures on the case of Ukraine versus Russia on Crimea. That's very important. There are lots of requirements to other countries and to Ukraine to conduct the proper investigation of the facts of human rights violation, which are acknowledged by the European Human Rights Court. And again, it shows that this ruling of the court is beyond peace deals. You cannot just say in the peace deal that you should not accomplish to the ruling of the European Human Rights Court, or you should not comply with the ruling of the International Criminal Court, or that the International Criminal Court should block this decision. Those are the points which are beyond political process, and Ukraine has to develop it. If we have this policy of fight against impunity at the state level. As of today, I still see that it is not at the state level fully. It is chaotic. We've got hundreds of people, and lots of presentees are here, who are on a daily basis doing a lot of work, but it seems to me that still those are little islands of work. We do not have the systemic work in our country, unfortunately. Thank you, Volodymyr. Can I remark? Yes, sure. That's what I was going to do, to come back to you. So now you'll have an opportunity to reflect on the speeches of others. And if I may, let me give the floor to Igor first, and then Andrei, I'll come back to you. And an additional question from me goes to you in the context of your remarks. Igor, can you define which main challenges are of your work during the recent 3 years, or maybe even more than 11 years of investigation, could you identify? And still, in the context of the international assistance, what we've got from the news during the recent months, what's the effect of this international assistance during the recent 3 years did you get? Thank you. Thank you for the question. If I may, I will reflect on the above mentioned by Volodymyr. First and foremost, still, I would like to specifically mention what I meant by 127,000 of criminal cases by Article 438. I did not include those articles which you mentioned. We don't consider the cases on missing persons so far as the crimes connected with the armed conflict. They can be considered like that indirectly, and only after we identify the fate of the missing person, if he or she is really jailed by Russian Federation, or we identify the person as unfortunately as an unidentified body, and when we find out the consequences of the demise of the person, then we change the qualification. If there is a reason, then it will be the Article 438. First of all, about the civilians as the protected category of the international humanitarian law. So let me repeat, 127,000 is by Article 438, which are registered by the national police. And here the highest percentage are the crimes which have something to do with shelling, and other types of war crimes like sexual violence, tortures, illegal detainment of the civilians is the category which, by certain internal treaties between the Prosecutor General's office, the Security Service, and the National Police, they were prioritized for the National Police. As for the torture chambers, in a nutshell as well, if I may. In fact, the National Police is dealing with the cases on torture chambers and the civilians staying in such places, the violation of their rights and the cruel treatment during the illegal detainment in such places, and documenting of such types of crimes. The National Police has documented 112 torture chambers in the occupied and deoccupied territories, and those places were created by the Russian Federation. Moreover, the National Police is dealing with these detainment centers on the territory of Russian Federation, where the civilians or the citizens of Ukraine are detained. The POWs who are released now are the subject for the security service of Ukraine for their criminal cases. As the outcome of the documenting of such places, the National Police issued notices of suspicion in absentia for 39 persons as of today. Those are well-known Olenivka colony, This is the former premise of Horlivka Center, Kalinivka colony, and Vovchansk factory, which were, and we were the national police were the ones who were working on such cases. As for the Interpol, as of now, this is the problematic, and in fact it is within your question on the challenges which we are facing. It was a huge issue during all of those 3 years about the opportunity of the international search for the suspects in the international crimes. Article 3, political motives and so on, is how the representatives of Interpol substantiated the refusal on the notice of suspicion for the war criminals, which our national law enforcement authorities issued. But as of today, I'd like here to make you aware that we have certain developments in this sphere. Our department of the International Police Cooperation of the National Police, which is curating, which is the National Bureau of Interpol in Ukraine, have certain developments and already outcomes. We have certain deals after the rotation of the management in the Interpol, when some people were fired, and we have the discussions of the mechanism of further work which lead to certain results. We are at the stage that some of the decisions can be taken about the search of such persons. And I mentioned something else. A European Court, a Human Rights Court. I would say it's significant when the aggressor country is not the participant and left the composition of the court. The rulings of the court won't be complied with by that party. Unfortunately, the microphone is not used. In this case, Ukraine will take the decision about investigation, but so far we don't have such cases, thanks God. I'm sure it will never take place like that. Now about the challenges. So, in fact, analyzing the report, as Marina mentioned above, the challenges, the number of challenges increases, and I'd like to say that all the above-mentioned challenges are the ones which the national police is facing with. Out of the additional ones, which I'd really like to mention, is the problematics. Well, we've already mentioned about Interpol, about the search of the war criminals. Not military, war criminals. Yes, sorry. War criminals. And one more key issue which I'd like to mention, and Andrei mentioned about that, the enforcement of the court rulings on the search, detainment of war criminals. This issue is the following. We are taking decisions. Oh, sorry, let me not take your time. Thank you, Ihor. And I'm giving floor to Andrei with additional questions. Because in the remarks, the emphasis has shifted to the crimes of aggression, to the perspectives of the tribunal, and so on. Still, I have the question, what shall we do with other types and categories of crimes? What's the perspective for the biggest amount of war crimes and potential crimes against humanity? I guess that during the next year we'll have the development of this qualification at the national level. So what's about the perspective on these cases, and how can the system cope with them? Thank you. Yes, thank you for the opportunity to have another speech. It's a hard question. The question of systemic work in the investigation of such crimes, prioritization of the investigation of such crimes, because the issue of prioritization is finalized when the victim is coming to you and says, for instance, my son or my father or my husband died at the front line. you have a criminal case, so what's the outcome? And we need to say, just theoretically, sorry, we apologize, it's not in the priority of our investigation, we cannot spend time and efforts to provide the necessary investigation of the above-mentioned crime. If we look at the number of crimes which are committed on a daily basis and which are in the pre-trial investigation stage, that is more than 150,000. The number of prosecutors and investigators hasn't changed since 2019. This number is in the law, prescribed by law. We cannot increase the number of judges and investigators, so we have to increase the workload. Prioritization really exists, however it may seem, and it can be done in a different way. Some people prioritize by getting quick results and outcomes. When we speak about such a negative phenomenon in our system of law enforcement authorities like statistics. But from our behalf, from the prosecutors and the management of Prosecutor General's office as a coordination authority for the activity of all of the law enforcement authorities, we emphasize that we are not interested in the number of criminal cases which you sent to court, getting verdicts or issued notices of suspicion. We are interested in the high-quality investigation, in the high-quality evidence collection, and the further perspective of the real conviction of the person for the crime committed. As of the systematicity of the work, considering the huge number of crimes which is already now and which will increase in the future, we decided that we need to separate the work between our pre-trial investigation authorities, that is, the National Police and the Security Service. This separation, this division, took place by the criterion of the inherent cases. The National Police is more taking the murders, the rapes, severe traumas, so these types of crimes were given to the National Police. I mean, if they are war crimes. The Security Service is prioritizing the state treason, the violation of territorial integrity, which is more inherent to them. So that is why the war of aggression is at the Security Service of Ukraine, because it is somehow similar. The violation of territorial integrity, the one is the tool of the other. So yes, there are certain issues. There are the opportunities to optimize our work, for instance, the alternative jurisdiction of the war crimes and their division and distribution by the decision of the prosecutor, or the facts of investigation by the pre-trial investigation could simplify the life of the prosecutor, but it's not that critical as an issue. And now the prosecutor's authorities include the opportunity to define a different pre-trial investigation authority if the investigation was inefficient. Taking into account such a number of crimes which are investigated by certain pre-trial investigation authorities, it is impossible to provide efficient investigation. That is why we transfer investigations from one authority to another. Speaking about prioritization, the case on mass murders in Bucha, for instance, it is in priority. It is being investigated by the investigative authorities of the National Police. The certain investigative group has been created. The priority is the following. According to this case, we are trying to construct, or I would say try to collect and prove the crime of genocide against Ukrainian people in that place. We are investigating them as war crimes. There are certain notices of suspicion against the soldiers of the armed forces of Russian Federation which committed those crimes against civilians. But there is an issue. Every investigation faces issues. Speaking about international crimes, they're also facing issues. But all of those issues can be solved both at the level of communications between the investigator and the prosecutor, or at the level between the heads of the authorities, or at the level higher, the level of the state. The state still, in its turn, has to provide us the tools which would allow us to efficiently investigate such types of crimes. Speaking about tools, those are certain norms and rules which are regulating the procedure of the collection of evidence, that is our CPC. It is very formalized, over-formalized, according to my opinion. Maybe you will disagree with me, but still. as of, for instance, the search of assets of the criminals who committed those crimes. Unfortunately, or maybe fortunately, we have such a situation that in the majority of European countries they don't have such punishment as the seizure of the property of the person who committed the crime. Since 2022, we sent certain requests about the international legal assistance to the countries where such assets were found, but according to all of the requests, they were getting the refusal. They were refused because such time of punishment as seizure of the property does not exist there. We don't stop on that. We are trying to find other ways to seize the above-mentioned property and to give it to Ukraine. One of the ways is the reimbursement of the damage by the crime for the legal entity or to the state. Andrei, you have just a minute left. So as for the majority of the crimes, those are the war crimes. Unfortunately, they are really numerous. We are trying to pay attention to the majority of those crimes, but still, coming back to the prioritization topic. If we started to speak about tortures, it is one of the most widely spread crimes committed in the detainment centers against both civilians and POWs. The ways of tortures are the same, the premises are the same where it is taking place, and the persons who are torturing people are the same. For instance, in the criminal case where they investigate such crimes committed against the POWs, 90% of POWs were interviewed, who were released from the capture of Russian Federation. That is more than 3,500 people. To process such an amount, we implemented certain analytical capacities. They are not foreseen by the legislations. They are not foreseen by any guidelines or bylaws or laws or internal instructions, but we try to process a huge amount of information to quickly find the people who are committing crimes or to find evidence against those people. So out of more than 3,500 persons, we need to quickly analyze these statements and find out how many people were staying in a certain colony who can make a statement about a certain head of the colony if he committed those crimes, if we get certain information which can allow us to put him under liability. As for the tortures, it is one of the priorities of the ICC. We are in the close cooperation with them. We are sharing the evidence which we collected, and we hope that soon we'll get the same outcomes about other war crimes, like the arrest warrants, but it's not our competence. I can assure you we are doing everything possible so that those crimes would be investigated and the evidence could be collected and given to the ICC. Altogether, what can we do with such war crimes? The only way out is to prioritize. A certain type of these crimes won't be investigated, whatever we may want it, but it is the reality of today. We won't be able just physically to investigate such a number of war crimes, so we have prioritization in certain spheres. That is the data for the aviation, the shelling from the strategic bombarders, then the treatment of civilian hostages and POWs, the attacks against civilians on the occupied territories, and the crimes of aggression. Those spheres are substantial as well, but they are covering the majority of 150,000 cases which are collected. The only opportunity to investigate those crimes and to take those people or the perpetrators under liability is to quickly collect this evidence without distractions.
Let me exemplify. There was this criminal case as regards Petrovsky, deputy of Milchakov. So we've collected the evidence in 2015, and we were interviewing the survivors. We interviewed those who were present at the location, and this very case was possible or was a success, actually, or became a success, just this year, meaning 9 years. There was a refusal to extradite this person, but on the basis of this, they were liable for bringing this person to a liability themselves. So their cases by 90% are based on the pieces of evidence that were collected by Ukrainian investigators. Then the prosecutors came to Ukraine, again with our participation. They interviewed the witnesses again, and the survivors again, and in April we are expecting a court ruling against this person that would be issued by the court in Finland. This is yet another important thing, because by these actions we are not just bringing persons to liability, the war criminals, but we are also bringing back the level of trust towards the judiciary of Ukraine. We are showing our capability. This is about us properly collecting the evidence, not violating the criminal procedural code, international treaties, meaning we are trying to actually prosecute these crimes, and we want the perpetrators to be put behind bars. Doesn't matter where, in Ukraine or in other countries. Thank you, Andriy. And continuing the reflections, Marina, I give the microphone to you. Please comment on what you've heard from the colleagues. And speaking about what was mentioned by Andriy, that now one of the priorities would be to collect all the possible evidence, to document it all. But at the very same time, we see the share of the cases that are being considered in absentia very quickly. So, what's the value of such processes? Again, against the background of these examples with the possible involvement of other mechanisms, and against the background of what Andriy mentioned about Finland, what can we count on potentially, and what's the value of this information in the future? Thank you. I would like to briefly comment what was mentioned by Andriy and Ihor. I can't quote Article 3 as regards Interpol, but to the extent of my knowledge, refusals pertained not just to political context, but the military one as well. This is not just about politics, you know. And Ukraine, I believe, will still be raising these issues at the level of international cooperation and actually enforcement of these court rulings. Maybe I'll comment separately on that. And I had this problem, you know, with enforcement of the rulings that were already issued. Speaking about priority, well, I strongly agree here. Now as never, I would like to have this unity with the pre-trial investigation units, with the prosecutors. I remember the first scientific conferences that were dedicated to war crimes, contextual elements, something that was quite novelty for us, and it was 2022, I don't remember the month, and back then we already saw figures at the website of the General Prosecutor's Office, and I had a question. I believed that courts actually find themselves in the stage of expecting something. We saw those figures, 50, 75, and we all know, there are 3 of us here, and actually just courts don't have the proper statistics. We are not based on statistics. That's how our work is arranged. So this is really the reality. You have to display the results of your work by the statistics. And we were expecting that there would be dozens, hundreds of crimes with due account of your statistics on your websites. But I can tell you on the 24th of February, there was the 3rd anniversary. And I had a look at the website of the Office of the General Prosecutor's Office, and it mentioned 152,000 of criminal cases within the war crimes. Well, And now I understand there won't be 152 separate cases that would come to court. No, this is about some smaller episodes that have to become a case for it to be looked into. But again, you've got these figures in your report, though they don't pertain the full-scale invasion only. You start with 2014, which is correct. But based on the most recent report of the General Prosecutor's Office, we see that within the period of 3 years, this is just 320 notices of suspicion and 250 indictments. And that's... Well, you may agree or not. This is not about statistics, for sure. And we see that, we understand that, and you are not in a hurry to send this indictment to the court saying that, wow, 10,000 indictments were issued in terms of war crimes. But I can tell you for sure that this is not about statistics, because I speak not just as a judge now, but as the common Ukrainian. We understand that within the 3 years of full-scale invasion in Ukraine, we didn't have 250 war crimes committed, right? So what is this figure about? It's just about indictments. Well, many more war crimes, unfortunately, were committed. Let me also touch upon the in absentia case. In this analytical reports, well, I understand you are drafting them. I love the style, by the way, of your report. It's very analytical. It gives food for thought, and you've aggregated a lot of information, and you refer to various figures, interviews. But in absentia, it turns into not a challenge, but a pain of this legal system of Ukraine, because we get criticism for this tool, both in Ukraine and beyond. But I will still stand my ground. This is not the tool of statistics. And this does not mean that we don't have quality behind the quantity. And to split my in absentia monologue into 2 parts. As regards the tool itself, as regards proposal and recommendations you provide in your report, I disagree a bit with those, but actually I will express this disagreement later when we drink coffee. So my personal opinion with due account of what I see, how I deal with this, how I work with this on a daily basis, and I saw this based on my lived experience. Okay, speaking about this in absentia tool, yes, it makes sense to have it, and yes, we speak that in the first place, this it's there for the survivors, for the victims. They have an opportunity to vent out, to voice out what happened to them. This can happen in the course of the court hearing, and the judge doesn't know what was voiced out to the pretrial investigation units, right? So, and that's the approach when witnesses and survivors can vent out. But yeah, these processes are there in the first place for the survivors. But we have to understand that when we speak about more severe war crimes, that's something interesting for the general public, and also there's an obligation for each and every one of us to collect evidence, to proceed with the investigations, and then it's up to the court to verify these pieces of evidence. And digital forensics is quite popular nowadays, and the methods of their verification is quite new to us. Then preventive function, we don't know whether it's a success or not, but the fact that in the course of the international armed conflict, Ukraine is arranging court hearings, I believe that's a prevention, all right. And there are other tasks, like respecting the historic memory and documenting everything that's going on. In your report, by the way, you are very greatly mentioning the problem with the material evidence. I never thought about this that thoroughly, like, large-scale material evidence. They can be destroyed because of the attack, and that can be a targeted attack to destroy the evidence. Then the issue with witnesses, I understand that. That's very relevant for all the other cases. A lot of people are currently finding themselves abroad, and court has got problems interviewing them, because we can interview them with the use of various technical means, but the person shall undergo identification. And abroad, not in every country, there are mechanisms of such remote identification for us to be interviewing a person. 1 minute, Kostya. Oh my God. I was sticking to the agenda before, so maybe you can give me more than 1 minute. So, speaking about witnesses, there's yet another huge drawback and problem here. They are mortal, right? And in your report, a lot of attention is paid to cases starting from 2014 that the world tends to forget about those early cases. This is 2025 now, and if this is not high time to consider these cases now, then when? Postponing of consideration of these cases is not about justice at all, and time plays against us. Okay, let me summarize then. Speaking about appeal and cassational processes, yes, the code needs to be amended, but not with this huge amount of rulings. This is irony, because there are just less than 100 rulings of the court. But, there's this social component in the legislation. Situations may differ. For example, this very ruling was already considered by the appeal court. This one not. So what's very critical within all of this, especially the cassational and the appeal instances would not pertain to all the in absentia cases, but enforcement of these rulings is something very relevant in every case. There's the convention ratified by Ukraine in 2002 about enforcement of court rulings. That's Article 25, which says that rulings in absentia shall be enforced as any other case. This sentence brings a lot of problems to us. You have this proposal and recommendation about actually missing persons search all over Ukraine. I have some questions here. Is this like searching for a person for the sake of just searching for this person? And again, there shall be some efficient amendments to the legislation. If all the in absentia cases are against the foreigners, and they are against foreigners in 99% of the cases, well, the only thing which is very great, I would like Ukraine to have the web portal or hub which would concentrate, well, not as we have it arranged now, because we look at the tribunal in the former Yugoslavia, but if this was a portal which would accumulate all the challenges, problems that could be discussed there, best judicial practices, this could be a portal that would be interesting for a lot of stakeholders. Thank you, Marina. And I give the floor to Volodymyr to wrap up our discussion. And, well, I'm warning all of you, we will drink coffee 5 minutes later than planned. And we still give opportunity to Volodymyr to reflect a little bit and think what kind of solutions we can find here, especially in the context of what's going on in these recent months, the possible negotiations and possible approaches there. I don't really like this discussions, because, I have to respond to everything that was mentioned before. This means we lack platforms for discussions. And there's really a certain problem with that. So, if we are exchanging some information here, I'm saying this is like that, somebody is disagreeing with me. I can also disagree with plenty of things that were mentioned just now, because I have enough of the information in my hands. And I like this report, because it's written in a very diplomatic language. Whenever there are some terrible things, and, for example, a child breaks a very expensive vase, and then you politely explain, no, this is a bad thing to break a vase like this. So that's what we see. That's what we see in this very report. Whether that's a good approach or not, I don't know, but I love the tone. We discuss very serious challenges here, challenges which shall be addressed here and now, because we are really stagnating, and in absentia is included in the statistics, etc. And we are actively using this tool because it stipulates for certain things which might move us or make us move in the wrong direction, and this could become a real problem. We need to discuss it more, and we need to have more channels with the investigation bodies in order to shape up the proper state policies for us to clearly see what are the problems and discuss these problems with all the stakeholders. Because again, we are not doing it all proactively. We are trying to solve the problems for a year or two. For example, victims.
It is an issue as well that in the majority of more than 200 verdicts, there is no reimbursement of damage for the victims. It is not there at all. Their function is just to provide the statement, the victim's function. But then to enforce these rulings, still the state does not feel the need to help them to enforce. When I told about the search of assets, I meant this very context. Of course, as for the crime of aggression, they wanted to take billions of Russian assets and to seize them from abroad. It's a simple way which cannot work in the lawful state, because it can be seized as the asset if it is connected with the criminal activity. But if we speak about the damage for the victim, in the majority of courts of the EU, they will be on the side of Ukraine. But again, can we have the system about that? No, because we still have the pilot office in the Prosecutor General's office for the support of victim, which is not embedded in the legislation. We don't have the legal substantiation for the support of the victim in the criminal case. And wherever you go, there is a huge obstacle of lots of issues which are not solved. I understand that we are working for 3 years ad hoc. We had the situation as response, and in the investigative authorities, we have this overwhelming of the routine, huge load of work. But it is high time to look into the future, as those investigations can take dozens of years. Israel is still prosecuting people who have committed genocide of the Jews during World War II. And I'd like us to prosecute those people for the next 2 dozens of years as well, the people who committed crimes in Ukraine. And it depends on us whether it really takes place or not, because it is possible to create mechanisms. We did not lose everything in spite of the peace deals, because no one can reflect in the peace deal that we need amnesty for those who committed tortures. So as for the substantial parts of crimes, maybe there will be amnesty, there won't be any investigation, but there are some of the crimes where there won't be amnesty, where nobody will be courageous enough to write publicly that Ukraine should be banned from prosecuting and investigating such crimes. As for tortures, we shouldn't be just interrogating or interviewing. There is the whole set of registering the torture from expertise and other points, and we cannot still take the DNA expertise. done in Europe for the Ukrainian criminal case, because only our investigator has to provide the necessary forensic expertise. So we, again, shouldn't go in circles around obsolete mechanisms. We should look forward into the future, how it should be done. Thank you, Volodymyr. I encourage our speakers to communicate during the coffee break, and using such an opportunity, if there are any questions, let us listen to one of the questions from the presentees and one online. Please think quickly and offer your questions. Are there any questions among the offline audience? Are there any questions among the online audience? Then I thank you for this discussion, and I encourage you to go on with it during your coffee break. And we are coming back here at 10 minutes past 12, and we'll go on with our conversation.
Dear participants, we are continuing the event. So now I would like to invite all the panelists to the floor. You all know who you are. I will introduce you later. Thank you. So as a reminder, we have a simultaneous interpretation. If you need it, because this panel would be predominantly in English, please use the headphones. Якщо вам потрібен
If you need interpretation, please use the headsets for the simultaneous interpretation, which can be found in the end of the room.
the channel in the Zoom. I feel like we can start. Good to go. I will also probably go in English, just given the constitution of our panel, but we'll switch if needed. Hi everyone, my name is Arya. I'm from ULAG, and I will be moderating this panel. And I will go through a brief introduction, but before that, I just want to introduce the panelists that are joining us today. And I feel like this is going to be an exciting discussion, especially given the context that we've got just earlier at the first panel. Here today we have Anya Neistat, a legal director of the Docket Clooney Foundation for Justice, Eric Whitty, independent rule of law and international justice consultant, former Open Society Foundation's International Criminal Court and Special Court for Sierra Leone, author of the book Option for Justice. We also have Irisa Chevra, who is joining us today online. Irisa, I hope you can hear us and see us. Yes.
Yes, thank
Great.
you.
Thank you. So Irisa is a former head of the legal advisory section of the Special Department for War Crimes of the Prosecutor's Office of Bosnia and Herzegovina, as well as a representative and senior fellow from the Georgetown University. We also have Nadia Volkova, founder and head of the Ukrainian Legal Advisory Group, the organization you probably know, as well as Roman Romanov, who is a Human Rights and Justice Program Director at the International Renaissance Foundation. So just a brief intro and to frame our conversation today, and then I'll pass on the mic. What we've heard just before is that obviously Ukraine is putting an immense effort into making sure that the justice and accountability are ensured for the grave crimes committed. Yet this effort is not taking place in a vacuum. It is part, albeit a great part, of the broader justice architecture for Ukraine that is complemented by efforts on the international level, starting with the direct or indirect assistance and support from third states, from international institutions, to help the domestic system and strengthening it to become more capable of administering justice on the domestic level, but also the international and foreign mechanisms and justice pathways that are being implemented to support and broaden the options for victims and survivors to get the justice that they deserve. This relates both to the International Criminal Court, to the third states proceedings under the principle of universal jurisdiction. We also have various initiatives and platforms that are designed to support and enhance the cooperation between all of these units, as well as various investigative bodies. And this is an important part of this landscape. A, because the support that is being given to Ukraine is instrumental to making it more effective on its own, but B, because we all realize that given the gravity and the scale of these crimes, Ukrainian domestic justice system requires help with and burden sharing from other institutions and mechanisms. So the key question is, do we have this justice architecture? Because in the context that we are in right now, especially after the full-scale invasion, the perception and the idea was yes, because especially after the 2022, we had a plethora of initiatives joining in the effort to ensure justice from all the sides. Yet 3 years on, we are on the brink of collapse of this justice architecture. Pardon me for such a pessimistic intro. So the question is, what should we do and how can we save it? What are the ways to ensure that these instruments and mechanisms are effective and are effective in complementing the efforts of the domestic system so that there are at least less accountability gaps than we have right now? I would suggest starting with the overview of the current state of justice architecture in light of these challenges that various justice pathways face, and therefore the accountability gaps that occur. And we'll go through various parts of things because there are, as I mentioned, many elements there. And I would suggest starting with Roman, if you could briefly outline the challenges that are there, especially when it comes to the geopolitical context that we are in and how it influences the justice processes, justice mechanisms, based or following on the opening remarks that you've made. I feel like that's a natural continuation of this conversation. So the floor is yours. Thank you.
Thank you, Arya. I think that maybe I would disagree with the word collapse, because we can speak about collapse of what exists and functions, what is working, but now we are speaking about a certain vision of the architecture which we are working on, and there is a certain evolutional development of that. Now we understand that it is fully possible that those expectations which were meant in the beginning could be hard to implement under the new conditions. And the processes which were beginning gradually, we can see that in the long-term perspective, they are still problematic to implement. So again, it means that we cannot just go with the flow and say that we've founded possible processes and it's important to go on with them, and we need to persuade the society and all of our partners that the continuation of the existing processes is the proper process itself. Because we can see that the risks have increased, and during these times the achieved results are not that numerous to say that we need to protect the existing status quo. So let us look around. In my introduction speech, in the beginning of our event, I already started to speak about that. So far, as of today, the processes of liability for the international crimes in Ukraine were not impacted in a disastrous way, considering these complicated political and geopolitical shifts which took place recently. First and foremost, the elections in the United States, but not only. But I think this is just a matter of time, because it's obvious that soon they will emerge. So far, I am happy that the worst predictions did not realize. As for the possible consequences and the format of sanctions imposed by the United States against the ICC, at least as of now, the Ukrainian investigations are going on. Still, we understand that it is a manual mode which has now been implemented. The decree of President Trump with an annex where they can add any persons depending on their foreign policy priorities of the American administration. Foreign policy priorities of American administration are hard to comprehend. I would so far leave this topic like this. All of those complicated debates around the General Assembly resolution on the 3rd anniversary of the full-scale invasion showed that this value dimension, which we're always basing upon and considered it to be permanent in the work with our partners, is not like that anymore. The achievement of peace is possible at the expense of complicated and bigger compromises. And undoubtedly it means that the organizations which are working with the victims, for them it is high time for those voices of victims to be better heard. And it would be harder to ignore them. Just now I've seen that there is a statement of the relatives of victims of the MH17 Malaysian aircraft, where the majority of the victims are the citizens of the Netherlands, and the relatives of the victims claim that within the negotiations, the interests of the victims shouldn't be forgotten and it shouldn't be the subject for compromise. For me, it's a very nice example what Ukrainian NGOs should deal with the ones which are working with the victims. This voice should be really loud. So far, we do not see any decisions and solutions. So far, I don't want to foresee anything for the future, and we shouldn't base upon them about our objectives. But still, we need to understand what already took place, and one of the phenomena which took place is normalization of dialogue with President of Russian Federation, as there is an arrest warrant from the ICC against him, so far at the level of bilateral relations with the United States. But let's say if they insist that in the negotiations process Ukraine should take place and the EU should take place, it may mean that this format can be expanded, and this normalization won't take place only within the bilateral relations with the US. The arrest warrant itself does not stop the diplomatic meetings at the certain platforms. It's not an obstacle, especially when the objective of those meetings is peace. But we are speaking about rather systematic policy which cannot be implemented just according to the one-time measures. So we can expect that this arrest warrant by ICC will be considered as an obstacle, as well as the possible activity of the future tribunal on the crime of aggression, and main provisions of the statute, as we were informed by the participants of the core group, were achieving substantial progress. As far as I understand, the statute itself is not approved, though it has the name already, a very loud Schumann name, but when this consensus is almost achieved, now we are under the threat that this communication during the 3 years, that we shouldn't forget about the crime of aggression, because the responsibility and liability for the crime of aggression has the potential to preserve the understanding of the war itself, what this war is, and that the whole Ukrainian society and the state have become victims of one and only crime, the crime of aggression, not just the victims of certain crimes.
So we've heard this communication. We've been listening to such communication for 3 years. To what extent this mechanism is important was mentioned. And now we can foresee that creation, establishment of such mechanism can be considered as an obstacle for further dialogue and achieving certain decisions. I strongly hope it won't be the case, but we cannot allow ourselves to exclude this prospect as such. And this means that those processes where we were trying to achieve certain progress are now viewed, understanding the additional risks that are emerging. So, if we don't achieve progress in this, will there be some compromises? Will there be some alternative approaches? And what would it mean? The impunity within the framework of achieving certain agreements there. At the previous session, we had interesting opinions about this, especially as regards the European Court for Human Rights, on the necessity to proceed with the investigation of these war crimes. But we can foresee that certain number of cases may be closed and a blind eye would be turned towards them. And this can be a precondition of an exchange all-to-all, which is important within each and every peace agreement. And we have a huge question here. What's next? What's going to happen with the whole evidence base collected and with all the efforts used? In what way we shall balance this communication and this work with the other countries where there were cases launched for the similar crimes and where there was no enthusiasm to investigate this crime? So will it give additional energy, additional boost for these investigations, meaning we are foreseeing a new reality within which we can't feel ourselves confident because this reality is not yet here, but we understand that huge, significant changes are possible and they can have great influence on the activities of our organizations. This would be it, and I'll be glad to have a broader discussion. Thank you, Mr. Roman. And I'm going to switch to Nadia now. In the context of what was mentioned by Mr. Roman just now, it's obvious that we feel this influence of strong states, and we see the influence of United States, this decision to seize military assistance. This could influence all the stakeholders, and this retailers everything, the budget, level of cooperation, everything that's manifested in smaller amounts of assistance and shifts the emphasis in terms of justice for Ukraine. So, taking this into account and in the context of other aspects of the role of the states, roles of the countries and the platforms which are still out there, what do you think, Nadia, where we find ourselves now, and do we have a chance within all this turbulence to still achieve certain strategic, sustainable development to make sure that the system is stable and can ensure the justice? Thank you for this question. Thank you, Mr. Roman, for the context you've just set out. I'm going to be in trend now, which I dislike, but I have to be in trend now, saying that, well, in trend, I mean in trend of the most recent political statements, for example, by newly elected Chancellor of Germany, then Mr. Macron, also started using certain rhetorics after Trump administration shook the world with their statements. They started saying, oh, we need to resuscitate Europe, we need to become independent, we need to cope with all our problems and issues in the first place to start with. I agree that it makes sense, but in what way? That's the question, which is important, at least for me. When we look at what's happening after all these numerous statements of Trump administration and Trump himself, after this executive order was issued on ICC, well, everybody's in shock and everybody is kind of paralyzed after this. So start searching for some efficient way out of this situation. Well, that's necessary, but how to do that? That's a question. Nevertheless, we are lucky in one thing. We have experience of working, existing, trying to do something constructive, moving forward in these turbulent times. We had this experience starting from 2014. Let us think back what kind of support we had within the period of time starting from 2014 to 2022. I remember us trying to work with Ukrainian Helsinki Human Rights Union, and together we were trying to boost all the investigation processes related to bringing to liability for the most severe crimes. In what way we were trying to develop good relations with the investigative bodies, with the prosecutor's office, and in what way we were trying to bring international experts to Ukraine. Back then there was no political will from the top, and there was no line of international experts to provide assistance to Ukraine. And the leadership back then didn't understand why that was needed. They were saying we can do it all ourselves. Well, the only thing back then, we were bringing those experts to various organizations for them to be talking about humanitarian law and its application. We've got this experience and it was not wasted. In general, within 8 years, we were successfully surviving without this assistance. When 2022 happened, apart from this being a huge tragedy, we started living in this illusion. On one hand, illusion that the world is supporting us, they are backing us, and now wise people would come and will solve all these problems. But unfortunately, the reality of today shows us that that's not the case. Let us think back in what conditions we lived from 2014 to 2022, and let us resume our independence and autonomy, because that's really us who need it all. We need to prioritize those topics and those areas within which we need international assistance of international experts, assistance with resources, not when they pour millions of dollars into your country and you don't know what to do with them, but when you are getting certain assistance and you know what you're going to spend it for, in what way you have to use it, and with it what time frame. And then I believe this makes us very organized, and we act and operate very efficiently, and we do not give a reason to various political actors to think that we are misusing something. Yeah, that's my opinion. So, speaking about what decisions shall be made, we were speaking a lot within the recent years about creating the tribunal for the crime of aggression, and I always strongly believed that this crime shall be paid special attention, and we need to practically understand how to investigate, how to bring perpetrators to liability, but also, and by the way, that pertains to the issue of prioritizing things. In what way we prioritize the real needs of ours? Well, for me, as of today, it looks like this spending of resources on the crime of aggression, so many resources, because we don't actually have the best approaches to do that so far. Maybe we need to reorient ourselves and deal with something happening here, right now, in real time, and there are victims of certain crimes. We see numbers of the survivors, and we have the best international practices. We know how to investigate it. Maybe we need to focus on that in the first place. And that's the issue of efficient use of resources. So I would reconsider this aspect as well. Thank you.
I feel like that highlights the point that prioritization and some sort of a strategic thinking as to what we should look into first and how the system should look is something that is needed, and at the same time is based on the actual understanding of the context and of the situation on the ground, of the challenges that are there in each and every justice pathway, and how do they face it. And that's something that is that influences the decision-making process quite heavily, particularly when it comes to the states that actually provide this support, but not just providing the support, also engaging directly in investigating and prosecuting grave crimes committed in the course of this war. And here I would like to turn to Anya and ask you, how do you see, given the vast experience that you have, especially in the field of universal jurisdiction, as one of the probably one of the prominent and vocal ways of ensuring accountability, especially after the full-scale invasion, how does this landscape look to you? What are the challenges that the countries face, or that the system face based on the approach that is taken, that maybe prevent us from fully utilizing the potential of the universal jurisdiction, and what are maybe the ways to address it? So over to you. Thank you.
Thank you very much, Arya, and thank you for the invitation to join this panel. First of all, I would support pretty much everything that the previous speakers have. The points that have been made are quite valid. I will just start with one, I guess, general remark, and we'll probably come back to it kind of in the second round of interventions as to whether it's a collapse, whether it's a doomsday. And I have to say that over the last couple of weeks, I've been going back and forth from absolute despair to some more rational thoughts as to maybe it's not as bad as it seems. I have to share with you the term that has been used by one of my brilliant colleagues, a very sarcastic man who said that we're all now palliative lawyers, which I'm now using in all conversations, hoping that it's not true, hoping that there is still hope for full recovery, but in some ways that's what it feels like. How do we, keep this patient, which is international justice and accountability, alive? So I do think that the situation is quite difficult, and it is a situation in which, as you said, Arya, I do think that universal jurisdiction, or broadly speaking, international justice processes at the national level, are probably one of the few remaining avenues, partially because it is something tangible that Europe, and frankly states beyond Europe, can do under the circumstances, where they will not have the same political constraints potentially, or financial constraints compared to other forms of support and assistance. And I do think, I would emphasize that we should be thinking outside of Europe as well, whether it's Australia or Argentina or Canada or other states on whose support we can rely, given the situation with the United States and potentially others going forward. The frustrating part here, of course, is that so far it hasn't been very efficient. You all remember, or at least I had massive enthusiasm in the very beginning of the full-scale invasion, watching European states, including the ones who have never been active in international justice processes, stepping up to the task, making massive promises and giving everybody a lot of hope that finally things might change. What we see now is, I would say, massive stagnation, and I'm saying it, watching it firsthand. We have filed cases, we have provided evidence, and so did many of our colleagues, and it just doesn't move. And frankly, there is nothing more frustrating, even more frustrating than some of the political challenges that we are facing right now, watching prosecutors in certain countries having full dossiers, being able to issue arrest warrants for some of the perpetrators and not moving an inch. And instead talking about structural investigations, evidence collecting, asking us all to provide them access to survivors and witnesses with no real promise to do something with this information. And that's, for me, is a massive advocacy point for us all. We always try to engage with prosecutors and police in those countries without public pressure initially, trying just to make sure, give them an opportunity to do their job. But there comes a moment where at least we start to feel that nothing will happen without significant pressure. And I think that's something that we should all focus on. And, Raman, I think your point about getting survivors involved in those processes, I very much support. It's hard. It needs to be done very carefully so that it's not, exploitative in any shape or form. But I also believe, at least, the survivors that we have worked with, that they want to go all the way. They already have done so much to ensure justice. They did not shy away, and I do think they would be willing participants in the efforts to put pressure. Finally, I would say that, maybe we'll go back. I do want to talk a little bit about some of the both threats and opportunities that current developments, meaning peace agreement potentially, would bring. But for now, I would just say one last thing. Again, going back to both discussing the crime of aggression and kind of alternative ways there. As some of you may know, together with colleagues from Legal Action Worldwide and Truth Hounds, we filed a complaint at the Human Rights Committee. And this complaint was not, a typical war crimes case. It focused on the right to life. We're still awaiting some communication back from the Human Rights Committee, but I think it's a very important avenue. And that's basically another way of showing that every Ukrainian is a victim of a much kind of larger crime than each individual war crime that we will keep investigating and prosecuting. Maybe there is a need and a way to expand this work. Obviously, that was one complaint based on a very specific case. We wanted to make it a testing ground. But given all of the work that is being done in Ukraine by Ukrainian organizations, by some international organizations, maybe there is a way of thinking of how we can make it, how we can enlarge the scale of this complaint dramatically. Again, from the advocacy perspective, that would make a lot of sense to me.
Thank you so much. And I feel like the word stagnation is is a very good one, both for the reason that it quite accurately describes the situation with universal jurisdiction, but also because it feels like stagnation is the state that can be altered in a way, right, at some point, but it needs some sort of a force to incite this shift. And one of the issues that we've been observing, at least, beyond the general reluctance to just apply universal jurisdiction principle by states overall, it's also some sort of a presumption that this mechanism is not necessarily needed or is not necessary for Ukraine context, because you have the domestic system, it's doing great, everything is fine, you'll manage, and there is nothing to complement, which, based on the previous conversation, based on the needs assessment report, seems like a fairly limited perspective, let's put it that way. But this kind of vision is also something that, this realization that the situation is a bit different also led us to the realization at some point that beyond the existing elements, there is also a potential need for additional justice mechanisms that might not exist as permanent ones as of right now. And one of such tools that has been already used and applied not once and not twice, but more than a dozen times in the last decades, is the special accountability mechanisms, justice and accountability mechanisms such as special courts or ad hoc justice mechanisms, the ones that are being created for a specific situation to adjudicate, investigate, and prosecute grave crimes. And here it feels like a good moment to explore this as also an opportunity and possibility for Ukraine to fill some of these existing gaps, to complement some of these mechanisms. And I would like to start with Eric. If you could provide us a bit of a, not necessarily even an overview, but your view and opinion on this mechanism in general, but also as to why this can be relevant for this context. So over to you. Thank you.
Thank you, Arya. It's a pleasure to be here. I'm really struck by the disconnect between the first panel, which was really focused on the day-to-day operations and sort of the iterative development of war crimes accountability in Ukraine, and very much with a view to its continuation. And then this panel's rather bleak, but I think realistic assessment of the existential threats to what has been built here domestically in Ukraine, and all of the really impressive efforts and really the tremendous goodwill by so many people within Ukraine's justice sector, among international partners, working with them, and at the International Criminal Court. It's been impressive, but it is under threat. There is the threat of pressure for wide-ranging amnesties for the entire enterprise to be forfeited through negotiations. There are security threats that I think need to be discussed. Worst-case scenarios. What happens if from a security angle, it becomes difficult to pursue proceedings in Ukraine in the coming months or years. And so I do think, given the grave risks of continued Russian aggression and the growing risk of American betrayal of Ukraine, it's time to think a little more broadly, to see this as an opportunity to reimagine an approach, and to take advantage perhaps of recent comments by Ursula von der Leyen when she was here talking about Ukraine joining European Union by 2030. So I think Ukraine should think about what it could look like to deepen its justice for war crimes in concert with the European Union particularly, and not just try to rebuild what's been broken, now again through the U.S. Cut of funds to the Atrocity Crimes Advisory Group, and other forms of assistance to Ukraine. And I think that has some advantages. It's a proactive approach. It's not, it gives a way to use the threat and turn it around, and try to accelerate Ukrainian reforms, which have already been impressive, but to take it further, build momentum, even greater momentum for the accelerated timeline of Ukraine's accession to the European Union. I think it could be harder, or I should say easier for Ukraine to resist pressure to drop cases if cases were developed as part of a hybrid or internationalized mechanism with the European Union that could involve Ukrainians continuing to work on these cases side by side with EU prosecutors and potentially support from other friendly states like Canada. And in the case of the worst case scenario, there could be a contingency that evidence could be relocated outside of Ukraine, and this could be a mechanism for that, for proceedings to continue outside of Ukraine if it came to that. And again, this is not anything any of us here want, and probably none of us want to even think about, but I think we need to. There's no set model for what this would look like in practice. There, of course, have been very many models of hybrid and internationalized mechanisms. We'll hear about Bosnia, which I think is a very interesting example. But it could be tailored for Ukrainian needs, the level of advanced Ukrainian expertise among its police and prosecutors, and really a way forward that provides an answer in solidarity with the European Union and European Union solidarity with Ukraine, despite troubling geopolitical headwinds.
Thank you so much. And I feel like in the current context, so to be very frank, we at the ULAG have been, advocating for this thing for quite some time, and the reason I'm saying this is that we believed it's a relevant solution for us, for Ukraine, also for quite some time, even before all of the disastrous developments that are taking place right now, even before the full-scale invasion. And all the new developments that we observe seem to just confirm that there might be a need, or that there is actually a need for this kind of solution, but also seems to create an even better space for this. So with the developments on the crime of aggression tribunal and the involvement of the Council of Europe, but also the European Union, as we've observed, it seems like there is a will to support some sort of a special mechanism. The question is what kind of mandate and how does it look? And but the fact is that it feels like it's getting more naturally involved in this conversation. Same goes with the potential risks of other things falling apart or stalled or being politically influenced, which probably is something that hybrid courts might be more resilient to, or even when it comes to some physical threats that are that we experience. But then the question is, this sounds a bit abstract in a way, without getting into specifics, or at least getting an understanding of how it can look and why this actually can be an opportunity for us. And here I would like to invite Irisa to share the experience or some insights from the Bosnia War Crimes Chamber, the overarching name, let's put it that way, but the one that consisted of several elements, as an actual example of how this worked. Obviously not ideal, as with any conflict situation, but probably the place to draw some lessons to see what can be adapted for Ukraine, or why this can be relevant and needed for our situation. Irisa, over to you.
Thank you very much, Harry. And greetings to all from Sarajevo. Hope you can hear me well. I'm really very, very, very delightful to be part of this panel and participate in the event. At the same time, of course, very sorry, for not being in Kiev with you due to really the situation that you already mentioned, and with the US funding. as well due to, it's not affecting only us, like in international consultants, but also it's affecting really accountability, international accountability efforts in Ukraine, which all of the panelists and people who spoke before really very eloquently described. And I would very much, and before I really dive into this Bosnian model, I was prompted really to just a little bit not react, but just try to add on what our previous speakers said, is that with all of them, I very much agree. To Nadia's point about this waking up from the illusion, what could be said is actually that some of us tried to actually in our talks with the Ukrainian counterparts, prosecutors, investigators, try to say, that things are, that they're looking very good at the moment, but they could change. Politics could change, and unfortunately, we are witnessing this today. But on the positive note, which I'm drawing parallel, to the Bosnian case, it is very good that we had this enthusiasm, from the starting of invasion until today, and that a lot of initiatives and efforts have been really taken and developed. And it is very hard to stop these initiatives. These accountability and broader international justice, transitional justice efforts. They cannot be stopped, by some current politics. And the reason I'm saying this is actually that, for example, the inauguration or establishment of the International Criminal Tribunal for the former Yugoslavia was in '93. And the Dayton Peace Agreement happened in November 1995. So I'm saying the accountability efforts really that are very enthusiastically started in Ukraine cannot be stopped for really in a very short period of time, and can be used really in a positive note. We heard word amnesties, some of these, but I can tell you some positive examples. For example, we passed amnesties laws in the Western Balkans in 1995 in Croatia or in Bosnia, and international crimes were not part of the amnesty laws. So these are some of the just positive and maybe optimistic signs that that all of these efforts are not lost. I think we just need to refocus, to shift, and maybe look just broader, broader out some models, that can fit. And I can assure you that we really that in Bosnia we always existed in a very difficult under very difficult circumstances, and of course we were lucky one that we had, for example, UN Security Resolution behind us, which you don't have in Ukraine, unfortunately, but you have a strong commitment from the EU, and Eric really nailed that very much. That you should use this momentum. That EU is willing, to integrate Ukraine into the EU by 2030, which would be really an excellent opportunity not to lose it. I'm now, again, really turning to this really how to look at these various models, and we are speaking about hybrid models of Bosnia and Herzegovina, Bosnian War Crimes Chamber at the Court of Bosnia and Herzegovina, Special Department for War Crimes in the State Prosecutor's Office that existed from March 2005 until the end of 2012. That how it can fit into the Ukrainian context. It will be a lot to cover, and due to complexity and in comprehensive efforts that were taken in these 7 years, but I will try really to focus on key aspects, rationale for establishment structure, a little bit of the structure, specific lessons learned, and really emphasis on the lessons learned. That as a way forward. For Ukraine. And when we are speaking about hybrid models, we are speaking about ideas, essential principles and features of international accountability, international justice, and not as some sort of advocacy or to integrate, because we know that this is not something in our hands. The War Crimes Chambers intended to provide highly specialized institutional and professional capacity to prosecute and adjudicate war crimes in accordance with international standards. Key factors that led to the establishment of this mechanism was the need of the International Criminal Tribunal of the former Yugoslavia. They were compelled by the UN Security Council to complete their mandate, to complete their ongoing trials by the end of 2008, appellate proceedings by the end of 2010, and it was so-called like a completion strategy. Under this completion strategy, there were like a twofold. ICTY needed to transfer so-called Rule 11-based cases, cases in which the indictment had been issued, and those cases were under, lower rank level perpetrators, and the broader also to transfer investigative proceedings against 40 individuals for which the investigation wasn't completed. These 40 cases, I think they were compiled in a little bit like a 10 criminal cases were transferred to the state prosecutor's office, more specifically to the Special Department of War Crimes. Internal reason for establishing this type of mechanism was that the state court and state prosecutors' offices, they got exclusive competence to actually investigate, try, and war crimes cases. That's another chunk of cases. It's the rules of the road cases, and that roughly involved more than 800 individuals that were classified into different categories, and those cases were reviewed by the International Criminal Tribunal for the former Yugoslavia. This is a good time to stress that the Special Department of War Crimes really had a huge backlog of unresolved cases that represented, the biggest challenge to deal with, and they didn't excel, at resolving this issue, and we will talk about it a little bit later. It is important to emphasize that this effort to establish Bosnian War Crimes Chamber was part of the broader institutional legal reforms and institutional reforms that were that were under the auspices of the strong international community in Bosnia. This is again time to to draw parallel with Ukraine and say that that you need a coordinated support from the international community. Right now, we can talk about EU. That is, I think, really a best partner, to really exercise that kind of role. Again, I mean, a little bit about the structure, not going, into deep, because it's really a huge effort. The court consisted of really the war crimes section that had 5 trial panels. That first consisted of 2 international judges, followed by 1 national judge, and then as of 2008, there was a prevalence that you have majority of national judges in that. Apart from this war crimes section, it was like a first instance that trying war crimes. We had appellate divisions, we had legal department at the state court management sections, public information offices, witness support section, administrative unit of the registry, criminal defense office. And they all consisted of national and international judges and professional staff. As for the prosecutor's office, you had 2 special departments for war crimes and organized crimes. We will naturally focus on the special department of war crimes. That has, until 2010, they had like international head of the department, and consisted of 5 geographical investigation and prosecutorial team with national and international prosecutor, legal officer, case coordinators, investigators, analysts, data entry and electronic evidence, evidence staff, legal advisory section that I ran for a while, research and analysis sections, and investigating witness support section.
Irisa, if you can hear me, sorry,
Yes.
If that's okay, I would ask you to wrap up for this part of the comment, just to be mindful of the time, but we will hopefully have another short round of introductions. So if that's okay, we will. I will probably switch, but if you want to finish the intervention up to a minute or something, that would be great.
Yeah. Thank you very much. Thank you very much for reminding me of time. I'm of course I'm losing track, and also with the interpretation. I'm trying to speak slowly, but maybe some of the lessons learned. That we can see it. That war crimes chamber really achieved overall efficiencies. They had results. That there are like 106 trial verdicts. They achieved a joint, coordinated, and highly specialized investigative prosecutorial work, as well as a highly specialized judicial work. And there was overall impact that can be that it was bolstering perception of fairness and helped to address any perceived bias. That I think it's also needed. Perhaps needed in Ukraine. There were also, international legacy that we very much use. Very much use the knowledge of practical guidance on practical guidance of substantive law, transfer of evidence, transfer of knowledge from the ICTY that really helped us shape. And this ICTY knowledge can be, ICTY knowledge is now part of the jurisprudence of the ICC, and now it can be used in Ukraine. Of course, there are many other, negative negative lessons that may be like a concrete criteria for measuring the effects of international involvement should be looked at and how to really and how to actually broaden this aspect. The result that were achieved in using transitional justice mechanisms like outreach were not fully supported. There are mechanisms that were related, like criminal defense and witness support and protection, that could be used as really good models and examples. I'm sorry that I took a lot of time, but hope.
I feel like that just highlights how much there is to explore, and I feel like that's basically the beauty of the practice and the experience that we already have in various conflict situations that Ukraine can draw from, which probably we should start doing even more actively than we've been doing before. And I feel like what you've said is, and some of the experiences that you've highlighted also showed that there is a way to tailor these ad hoc solutions to a context of the situation, and not just to put it on, somewhere out of nowhere, but rather to infuse it in the system and help through this hybrid court strengthen the domestic system through the cooperation with the national and foreign specialists, through the legislative reform that comes before or throughout the existence and operation of such courts. So this is not necessarily, the pill that just comes in and fixes it all by itself, but rather a solution to help and somewhere patch some of the gaps, but also help heal some other mechanisms that are in place through the cooperation in between these mechanisms. Before we go into the second round, given the time that we have left, I would actually want to ask the audience, both online and in person, to see if there are any questions as of right now that you have for the panelists, so that they can maybe respond to some of those throughout the second round of the comments. That's fine if you don't have any, I'm just checking. So do we have any questions here in person, or maybe anything in the chat or online? Nothing so far, which is from the logistical perspective is great. So with that, but please feel free to actually ask questions. That's something we aspire to. With that, I would probably like to turn in a similar order, but I would switch it a notch. To Roman again, and here this would be an opportunity to reflect on various parts of this conversation, not necessarily limiting ourselves to the ones that we've been intervening on the first time, but I guess from the perspective of moving forward and addressing the issues that we feel that we face right now, and how some of the mechanisms that have been that were explored throughout this conversation, how can they help? I know we had a conversation about, for example, the potential increasing relevance of the hybrid court in the context that we are having right now. Maybe there are other issues that you want to highlight. If you could keep it to 5 minutes, that would be nice, and I would ask each panelist to be mindful of the time. I will remind you, of course. Thank you.
Thank you, Ari. I'll be brief.
I believe I won't take even 5 minutes for this very statement. Okay, that was a very visionary session with experience sharing, with voicing out appropriate ideas, with attempts to understand the problems profoundly, what we can expect from the future. And against this background, I believe that for sure we need to be open right now to various ideas and various opportunities coming our way, because the situation is very dynamic. And I believe what shall remain unchanged, that would be a dedication to the priority of not letting the impunity rule the world. And we need to bring justice to the survivors and victims, because they shall hear some signals of hope for the justice. And this is something I would really like us to be mindful of. We can't afford any other format of communication, but inside the community we operate, we need to be looking for answers to all the questions, and we need to try bridging all the gaps. The special mechanism, yeah, I was a proponent of it for extended period of time, and I believe it can be a certain solution. But as Eric was mentioning, every mechanism shall take into account everything that's going on around us, right? So far, some mechanisms are not comprehensively taken into account all the factors. Well, if we speak about crime of aggression, in essence, we found the consensus resolution. That's the hybrid mechanism, and there are certain risks for the national investigation. So maybe this hybrid mechanism can be extended from the viewpoint of the category of cases it can consider. But it's not as simple as well. This is a very non-linear situation, because taking into account that we expect certain consultations and negotiations in an unknown format, I would really expect that Russian Federation would try to limit Ukrainian sovereignty, and these limitations would pertain introducing changes to the constitution of Ukraine. And I believe in this sense, we need to be thoroughly having a look at the experience of Bosnia, because in no case we can have Dayton variant for Ukraine. This shall be really excluded from the agenda for us. And if we have a look at the political situation in Bosnia, this format of peace led to significant stagnation in the development of the society itself for decades ahead. As far as I understand their experience, and based on my study tours to Bosnia. And in this case, it's very difficult, it will be very difficult to communicate on the issues. You know, if we agree to the special mechanism, we need to be discussing limitations to Ukrainian sovereignty and involvement at the constitutional level of judges from other countries, etc. So, this is a situation when we need to be swimming against the flow of the river, and this entails some difficult talks. So the Ukrainian authorities shall be very sure of their position in this peace negotiation processes, and also we need to have support of the civil society in these processes, and we lack both in order to promote this agenda today. But this does not mean that we shall not be considering at this stage mechanisms like this, because the worst case scenario, and I was trying to actually describe it in my previous statement, meaning if there are too many limitations for the available mechanisms, then we need some other solution. Mr. Eric was mentioning a lot of important elements that can be the constituent elements of this solution. So in this context, I think we need to support this communication. We need to be looking for all the possible variants out there, but for sure we don't speak about actually replication of any mechanism. This shall be a solution that takes into account all the factors, and some of them are not yet sustainable. We need to be ready to the fact that we would have a very loud voice when this voice will be needed. Now we are trying to search for some solutions, to discuss all the solutions, and we speak about bringing people together and having some common ideas there. Thank you. Thank you so much.
I would switch to Anya for now, and I feel like because you've mentioned some of the more broader remarks that you had in terms of the justice architecture and the challenges that we have, and maybe to an extent, if I can ask, while the states, as we've learned from the previous conversations, are not as mobilized in the current context, it also feels, as Nadia, for example, said, that there is sort of a wake-up call or awakening situation happening. So with that in mind, but also with regards to everything that we've been discussing so far, do you see any points or things that we need to bear in mind moving forward, or some of the solutions, how to address the issues that we have outlined earlier?
Thank you. You are trying to awaken the optimist in me again. I'll do my best. Thank you. I think having listened to everything said on this panel, by the way, lots of, I think, very interesting thoughts and suggestions. And I know in some ways we have been talking about all of that for at least 3 years, and many of you for much longer. But I do feel that at this moment there is a different light put on various options at the table, including the hybrid mechanism, which I frankly was quite skeptical about in the beginning, and now much less skeptical given everything that's happening. But I do think that, and that I will get to what the opportunities potentially are, but I think when we discuss opportunities, it's also, I think now is the moment to take stock and decide what are we actually trying to achieve here, both long-term and in the process, right? And our decisions on which mechanism to support, on where to put our efforts and our money, should also be seen through that prism. And here, I'm sure there's a difference of opinions. One could be just full-scale documentation, making sure that no crime is undocumented, that all survivors, that's related to the question of reparations and all of that, right? Another approach is to say that obviously we cannot put everybody behind bars, but our goal is actually to make sure that the key perpetrators at various levels end up behind bars. Not just tried in absentia, not just with arrest warrants issued against them, but actually behind bars. And so, as we're working towards either of those dimensions, or both, or some combination there is, that I think defines the next steps. So for me, in terms of immediate needs and immediate opportunities, with those longer term goals in mind, preservation of evidence, and making sure that all the work that has been done so far, particularly at the national level, is a top priority. I don't know if we still have some of the colleagues from the law enforcement agencies with us here. I probably should have asked this question during the first panel, but I'm a little bit concerned that at this point, the conversation felt almost like business as usual, and I don't think it is. I do think that it's very important to continue the efforts, but I would like to hear a reflection on what a potential peace agreement could mean to these efforts, and how the police, the prosecutor's office, SBU, and everybody else is preparing for what it would mean for justice processes nationally. And for all of us, both Ukrainian civil society and international organizations, it's also the question of, depending on what the scenarios might look like, what the potential solutions are, including, for example, the transfer of evidence to a potential other mechanism, or at least repository of evidence somewhere, so that it's just not lost, so that, eventually we could pick up those efforts. And another point, and I won't speak for too long, but another point, I think, a point of opportunity for me, if there is a silver lining out there in terms of this normalization of Russia broadly, Putin and others, is that there is a chance that their larger acceptance on the international arena will mean more mobility. And more mobility means more opportunities for actually apprehending them. And, call me an idealist. Of course, it will always depend on political will, but the more Russia is isolated, the more they're stuck inside, right? The less it's isolated, the more likely they are to travel. Whether various countries would actually go ahead and arrest and extradite them is a big question mark, but I will repeat what I say in almost every panel, is that unless we have arrest warrants now, these people will travel and there won't be even a possibility to arrest them. And we would have to start from scratch, as happened many times in the past with other situations. And that is something I think we should be conveying to all of our interlocutors, especially in Western countries that are pursuing these cases, is that they should not wait for too long before they issue arrest warrants, because that will at least create opportunities for future prosecutions.
Thank you so much. Exactly. I feel like that's the understanding that there's no time to wait for an ideal moment when everyone is coming to a bench and saying, well, please, adjudicate me for whatever I've done, and creating as much of a ground, especially when there are legal grounds for conducting this kind of efforts, could help be ready when the time comes, no matter what the circumstances are, if whatever perpetrator ends up somewhere on foreign soil. And here, to continue shuffling the cards, and I also seeing the hand raised by Irisa, I would like to invite you to weigh in on this conversation. Both in terms of the Bosnian experience, but also more broadly, as you have been also actively involved in the work on justice for Ukraine. I would still ask you to keep the remark 5 minutes top, and we'll remind you once it comes to this mark. But over to you.
Thank you very much. Ari, and it will not come, I think to this really remark, it will be much shorter. I'm very glad that Roman mentioned Dayton Peace Agreement, and I'm very much hopeful and happy for Ukrainian people that they do not have they have actually Dayton Peace Agreement as some example, not that shouldn't be followed, as a long-term solution. Not even to stop the war or to rebuild the country, but I was trying in my previous intervention just to really emphasize some good points, to say that accountability efforts were never ever a question in the Dayton Peace Agreement, and maybe that should be like a silver lining for all of this. Another thing is about that's really it's on the very much re-emphasizing Anya's point of view is that that Ukraine needs to continue work really on preservation and collection of high quality evidence in line with international standards, and to use like these lessons learned from Bosnia, that to continue building comprehensive institutional, judicial, prosecutorial, defense, and support capacities, and to have also timely strategic approach to atrocity crimes, investigation, prosecutions, and adjudications, including this collection of evidence, which I will repeat because of its relevance, more than once, and having mapping and prioritization of cases. As well as to work timely on transitional justice efforts. We failed very much on that in that field. Legal reforms that are also needed in strengthening the Ukrainian substantive and procedural criminal law frameworks are very much needed. Fortunately, you have ICC here, and it could be a good guidance in terms of jurisprudence, international crime, substantive law procedures, evidentiary proceedings, standards of proof, case law standards, and they should continue to transfer their knowledge to Ukrainian prosecutors, investigative judges, defense attorneys, as well to use their ICC databases. The reason I'm also really stressing this out is actually, even in this political moment that we are in, there is no one in the world that can actually derogate, use against peremptory norms, international customary law, also the ICC statute that compiles all of this jurisprudence and the customary law and all of the really results of international justice so far. And also we have the Geneva Convention that are still in play, genocide convention, they are valid and no one can derogate them. So I hope this is not too optimistic, but but we need to remain vigilant and to continue work regardless of how hard the circumstances around us are.
Thank
you. Thank you very much.
Thank you so much. And no, I don't think it's overly optimistic. I feel like it's a necessary optimism that in this context, which at the same time feels like needs some sort of instrumentalization, right? So some structures that can ensure that, as you've said, none of these international agreements and rules are derogated in any way throughout the process, or at least to mitigate this risk if we are back to the realism part. And I'd refer to Eric now and ask you to weigh in on some of these conversations. Again, not necessarily limited to the hybrid options, but overall, what are your thoughts on ensuring these goals as we've been discussing this during this panel?
Thanks, Arya. I want to pick up on something that Anya said, and I couldn't agree more. I mean, we need to start the discussion about any new approach with what are we trying to achieve? What's the purpose? And that's the first question that anyone should ask when thinking about designing a new accountability mechanism, and everything else should flow from the answers to that. Is the purpose, just to try a certain number of cases of certain kind? Does the purpose, how does this mechanism fit with other jurisdictions like universal jurisdiction or the ICC? How does it relate to other elements of transitional justice, truth-telling purposes, memorialization? And then from that, like I said, all the other elements of mechanism design flow. What are the structures of this? Where is it located? Are there maybe a contingency plan for a different location, if need be? How is it financed? What's the oversight? All the rest. I think under the circumstances, another key question is what happens to the archives, the evidence, right? And again, I think the advantage of a hybrid is that it could provide that an answer to that question, that if case files come under threat, they could be moved to secure location and perhaps brought back at a later time. When it comes to memorialization, I mean, I think that's another thing. If there's a pause in Ukraine's justice process, I mean, I think it's useful to look at what other experiences teach us there. And I'm recalling when Slobodan Milosevic died before the end of his trial at the ICTY, civil society organized kind of a roving tour of evidence from the trial that was brought to different capitals and I think went around the region. I don't remember the details, but I mean there are a lot of sort of ideas of what can be done to tell Ukraine's truth in Ukraine and around the world, even in the case where formal accountability is put on hold. And maybe I'll just finish by saying, the other advantages of a hybrid type approach is it would provide a channel for all of the international support. And we've seen Ukraine just receive a remarkable influx of international support following Russia's full invasion in 2022. And it hasn't always been coherent, despite best efforts of the Atrocity Crimes Advisory Group, other efforts to coordinate, but it's been quite chaotic. But if there were one hybrid mechanism, that would be a way for also the international community to reorganize and reorient its support through one focal point. And a final advantage is it would give access for trials to victims or witnesses located outside of Ukraine, which has, of course, been a challenge.
No, for sure. Thanks so much. And I feel like exactly a hybrid of court potentially is an option to reconceptualize the way that we build the justice architecture for Ukraine. Again, not necessarily to say to replace any of the mechanisms, but rather to complement and probably rejuvenate them even, first and foremost for the domestic system, because we see right now how affected it is in terms of capacity and potential because of these political shifts. And thinking about how to ensure there is no such, or at least less of a situation in future is also important, and maybe hybrid can be one of the ways to ensure that this system is more rigid in a way to such frictions and turbulences. And for a final remark on that during this panel, I'd like to invite Nadia, and maybe to reflect on everything of what's been said, but also weigh in on some of the ways moving forward. Over to you.
Дякую.
Thank you, Arya, and I thank you for all of the remarks today and for the inspiration to think a bit again. What do I have as a lesson taken from today's discussion? That today, among the presentees, and I hope that the online and offline presentees have achieved consensus that justice in the context of the armed conflict in Ukraine, of Russian aggression against Ukraine, has to take place. It seems to me, I personally, definitely, I'm not ready to refuse to deny this idea under any circumstances. Maybe because lots of efforts and resources were allocated for that. Maybe because I always considered that what I do is my vocation. And just to contradict this is just destroying me, even mentally and internally. So going through this way, which we overcame, and after living this war during the, after living this life during the war and surviving, as some of us have survived and can do something to provide this justice, it is our obligation, finally, in the end of the day. And it will be a crime to not to do that. But, on the other hand, I agree with Roman that now, in these processes, maybe there will be a little break, a pause. But this suspension shouldn't be empty or void for us, for those who do that. Yes, there are lots of external unknown factors. We don't know what the end of the peace talks will be. We don't know which compromises will be achieved. But if we decide that justice has to take place, many of things should have been done during this break. I mean internal work, domestic work. And what we need to work on is all described in the report. We need to go on developing the system. We need to go on improving the legislation. And in fact, we have some of the factors which can help us in that. That is the process of the accession process to the EU. And it's more or less sustainable guarantee that we can and we have to work in this direction. And finally, I think that the EU countries and institutions of the European Union will insist to go on this work. Then I really agree with what Anya said, that we need to preserve evidence. In this aspect, really, we need to think and prioritize as of today this issue. Together with Marina, we had a conversation during the morning coffee that really there are archives, but it's a challenge for the state, because all of this information is preserved in the internal servers, in their own computers of the law enforcement authorities, and it's not the best option for the current situation. We need to think on how to secure this information from the external impact, from its deletion during hackers' attacks, from the leakage of data, and so on. And the third aspect, which seems to me also should be a priority, it's not directly about the justice procedures, but still, it seems to me directly influences the future, which is awaiting for these processes. That is the high-quality diplomatic work of Ukraine on the creation of partnerships with the countries which are our allies and which we consider that we need their support. But that's a separate topic. When we spoke about the EU countries, it's just one aspect, but on the other hand, as Eric mentioned, this could be Canada and Australia and Japan. We need to think on the geography, to sit and to wait in, and to think and begin a very substantial diplomatic work, developing partnerships and support. Because both ULAG and I, we go on believing that internationalized or hybrid or whatever you name it, mechanism has to exist, has to take place. It will make us stronger. Definitely it will not make us weaker. But so that it could take place and be of use as it can be useful, besides the creation of this vision, we also need to provide its functioning. Not only relying upon the experience which we already gained and the expertise which exists in the world, but also we need to provide some of the materials to work with. We need to provide it with the witnesses and to provide the opportunity for the victims so that they could come and tell their stories, could be heard. Maybe they could look into the eyes of those who brought pain for them. And in fact, it seems to me it's a substantial challenge which we need to think about as well, and we need to find certain solutions for that. It is our internal domestic work, let me repeat. I'm sure of that. If we don't accomplish this work, no one will do that instead of us. Thank you. Thank you so much, Nadia. I have the feeling that we are moving from the end of this panel to the final remarks altogether. That is why maybe my question will be, are there any other remarks left among our panelists, Nadia, maybe Roman, about the whole event? Because I have the feeling that we are already finalizing the work. If there are no final remarks, considering that we have some time left, we can give the opportunity to the audience to pose some questions and to reflect on that, on this panel and on the event and the whole current situation. So if anyone among the presentees or online, if you have any opinions, ideas, reflections, if I may, not very long, but still we would be happy to hear them, please leave them in the chat or raise your virtual hand or here offline we'll see it.
Oh, we won't see your hand unless you raise it, but I don't see any questions, right? Good. Then, Nadia, I give you the floor for the final remarks. Oh, just give me a second before you switch the mic on. To wrap up with the panel discussion, I would like to express my gratitude to all the speakers, because I believe this panel was a success, a very interesting one, and that's thanks to you, dear panelists. I believe the conversation was really fruitful and interesting. Yeah, so I have already mentioned everything I really wanted to during the second round of interventions, but I would like to express my gratitude to our speakers, dear guests who came to listen to our statements, to reflect a bit. Maybe they found something interesting and useful in these discussions, and we are always glad to get the feedback. We also plan further updates, because that's a non-stop process right now, as Volodymyr correctly mentioned, until we see that the scope of the document is decreasing rather than increasing. So please call us, come and be our guests. Let's drink coffee together. We'll be glad to discuss any pending issues and reflect on your proposals together. Thank you so much. Let's drink some coffee then. Thank you.